Sir, how'd you get here today?
My old lady drove me.
I'm sorry?
My old lady just drove me.
Your old lady?
My girlfriend.
That's probably a more appropriate way to refer to her. Is she older than you anyway?
Yes, ma'am.
By a lot?
About 6 years.
Okay, well, still doesn't make her an old lady, but okay. All right, ever failed to appear in court, sir?
I have never appeared in court before. This is the first time.
Right, but were you supposed to have appeared in court and then you didn't?
I believe so, yes. I believe so, yes.
Is that why
I was in and out of living situations with my
Okay.
address. I didn't really get all my tickets in the mail. That's why.
Okay, so is that why you're suspended, sir?
Yes, ma'am.
Okay. All right, so sir, no driving. Where do you work?
I work at Taylor.
And how do you get there?
My old lady drives me. My girlfriend.
You might want to start thinking about it in a little more respectful terms, sir. All right, no driving. We'll see you back on June 10th. Have a good day. Okay, so how did you get here today, ma'am? Okay. Do you have a valid license? You can't drive. You can't drive in Florida, you can't drive in Michigan.
I know. I lived in Farmington and I had no other way to get here. I tried to reschedule it and I couldn't reschedule, so I didn't want to miss it.
Okay, so what about Uber?
I can get an Uber.
Take the Uber down here. I'm not throwing Uber over anything else. That's just the first one that comes to
No,
my
I
head.
understand. My fiance lives in Rosedale and my phone was there, so I didn't have any way to get an Uber until I got down here to get my phone.
So you went from Farmington to Grosdale to here?
I just want to be honest, yes.
Okay. So who's going to get your car back somewhere?
My fiance will take care of it for me.
If
Yes.
they're gonna be watching, you cannot leave the parking lot driving.
I totally understand.
The court's going to order a $5,000 personal bond, no driving at all.
Okay.
Okay? You've already been given an opportunity to have some things cleared up, to maybe have a better option of a resolution. If you're caught driving between now and then, that's likely off the table.
Okay.
All right? All right, we'll see you back on June 10th.
Thank you.
Thank you. All right, have a good day. Off the record.
Okay. Go!
Hand me my screen box. Now go. Freak.
All right, so let's go on the record of the matter of the city of Riverview versus Sharon Comrouse, 232527.
Her daughter's in work with, if you might speak stuff up as well. Well, it's up to you, obviously.
I mean, she can, she can't, you can stand up next to your mom, ma'am, that's fine, but I just can't have you, answering for your mom or anything, okay?
Thank you.
Okay. All right, is the accident interfering with her record?
No, I think so.
Okay, I'm just gonna need you to be as loud as you can, okay, Ms. Comrouse? All right, I'll just need you to be as loud as possible when you're talking, okay?
Yeah.
So I'm going to need you to be, so you know what, counsel, I wonder.
I'm hard of hearing you. I'm a little hard of hearing.
Okay. So, would it be a detriment if you turned off your oxygen for a few moments? Would that be okay?
Okay.
All right, that might help in hearing as well.
Okay. But I don't think she said. I didn't understand what she said.
Wants to shut your oxygen off so they can hear better. Are you okay
Oh,
with
I'm
that?
sorry. Okay.
So that,
For a few minutes?
so that you could hear us better,
I'm okay.
okay? All right, it's okay for a couple of minutes for that to be off?
Yeah. Well, I mean, it's just a little hard of hearing, so.
Okay. So, counsel, your appearance, please.
Yes, good morning, Your Honor. Neil DeBloy here on behalf of Sharon Comrouse. Stands to my right. Ms. Comrouse, can you state your name, please?
Sharon Comrouse.
All right, very good. Good morning. And today is the adjourned date for the pretrial. And the parties have previously been ordered to mediation. Did they participate in mediation?
Here's my understanding. Yes, they did participate in mediation, but there was no resolution
Okay,
of the case in mediation.
okay,
Today, we've had a chance to speak with the city attorney, and there's a plea before the court. My client's prepared to plead responsible to the added count of loitering, the original offense would be dismissed.
And there's no request for restitution, counsel?
No.
Okay, can somebody have Mr. Carmen log on, please?
If the city attorney is gonna,
Ma'am,
is it okay if I sit down? I'm sorry.
Hold on. That's why you're not identified for the record. That's why I said you couldn't address the
Oh,
court.
I'm sorry.
So your name for the record, please, and if you can state and spell your first names.
Roxanne Shaw, Roxann.
Okay. And I'm sorry, you said because the prosecuting attorney is coming in, you would sit down?
Yeah, I just don't wanna be like in the way.
Oh, no, you won't be in the way.
Oh, okay,
But you can sit down if that's what you want to do, ma'am. That's totally fine.
okay.
Good morning, Mr. Carmen. If you could please place your appearance on the record in the matter of Sharon Conrouse, please.
Michael A. Carmen, P73824, on behalf of the prosecution, Your Honor.
All right, thank you. And so I just want to confirm, counsel, that there is not any request for restitution.
Now that I know of, Your Honor.
Okay, and you had conversation with the complaining witness in the matter to determine that?
Your Honor, I did previously, and she stated that no.
All right, and so, okay, so Ms. Conrouse, can you please raise your right hand? I've never been accused of being quiet, but I'll yell even louder. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes,
Okay. You heard the plea that your attorney placed on the record, correct?
correct.
As to the amended charge of loitering in a public place, how do you plead? Responsible or not responsible?
What? Responsible. Responsible.
And you've gone over your advice of rights with your attorney, correct?
Correct.
You understand all of those rights.
Correct.
And the court does find the plea as knowing and voluntary. The court will accept your plea per the plea agreement to the amended charge. And that's $150. Do you have that to pay today?
Okay. Yes.
Okay. All right. So ma'am, I'm going to state this as well. Apparently there's some discord between you and your neighbor.
I'm sorry, I didn't understand.
Apparently you and your neighbor do not get along very well.
Correct.
Okay, so stay in your lane, your neighbor stays in their lane. Okay? All right, just have a seat in the lobby, somebody will be with you shortly.
Yes.
Thank you.
Can I say something first?
Okay, what's that?
I tried to get my driveway widened to get rid of the rock. I mean, I tried everything. I took called 6 companies that do cement work. None 6 of them called me back. They didn't answer the phone. I left a message. They didn't call me back. Yeah, Lord knows I've tried.
Okay, well, I know you may not like the rocks, but if they're on their property, they can do what they want over there. So
It's my property and what?
I said, I know you don't like the rocks,
Right.
but if it's on their property,
It's not. Not mine.
okay, well, then you might want to talk to the city and building department about
Give me the
the
complaint.
survey, about the surveys. So,
I did a survey and, okay, never mind.
okay, I can't help with the survey issue, so, okay. All right, have a good day.
Thank you.
Okay, thank you. All right, we're off the record for a moment. All right, let's go on the record. In the matter of the city of Wyandotte versus Shelby Philipsky, 232344A.
Good morning, Your Honor. Harold Lloyd here on behalf of Shelby Philipsky. Stands to my right. Ms. Philipsky, can you state your name for the record, please?
Shelby Blitzky.
Okay, all right, the court will note, as I did previously, that Ms. Philipsky works at a local establishment here in the city, and that I have participated in some
Yes, Your Honor, I recall, and she has no objection to you hearing this case.
okay, I would say that I have not been here since this matter's been pending. I have not been there. Is that accurate? Is that yes?
Yes.
Okay, all right. And, okay, and so,
Your Honor, if it please the court, I'd like to make a a statement before we begin the proceedings?
Okay, well, let me just state here. So Ms. Filipski was arraigned on February 14th. And she was ordered not to possess or consume any alcohol or drugs that are not prescribed. And she was sentenced on March 25th. And she tested positive on March 27th. And based upon the proximity, and actually also on the 26th, based upon the proximity to the date of sentencing, it's scheduled for a bond violation as opposed to a probation violation. And you, counsel, what is it you wanted to state?
Yeah, just to sort of frame this, it's difficult for the client to respond. So obviously I'm responding on her behalf. The idea that this is so close in time to the point of the arraignment, she was ordered, she maintains her innocence since she has not violated court's bond conditions.
Okay, I'm sorry, counsel, let me just clarify one thing. It wasn't that close to the arraignment. It was close to the sentencing date. That's why it's set for a bond violation, not a probation violation. She was arraigned February 14th. This was collected on March 26th and March 27th.
Yes, my client maintains she did not violate the bond conditions nor since being sentenced to probation. I'm not aware, look at the file, I've not been notified there's been any additional violation. She's continuing to test. As she testified at sentencing, she was a long-time regular user of marijuana. She'd never had a marijuana card, although she's had discussions with her physician about this. And, you know, she maintains she has not violated the court's orders, whether they be bond conditions or whether they be probation conditions. The record reflects that there was another test on April 15th, which came back negative. A very short time after the alleged positive testing. And since then, she's tested several times, and there is no evidence that she's doing anything but complying with all the requirements of the court. The court's also aware of the fact that she attends band meetings and that she's done the chemical awareness program. So, but at the same token, she is innocent of any, I won't say intentional, but any violation. And so I appreciate the fact that someone from the testing company is here. There's no evidence, there's no proof. She's going to prepare to testify that she's been faithful to the court's orders. And if the test itself, we're not scientists here. I don't know if the person prepared to testify is a scientist. You know, just going forward here, or she is not standing there stamping her feet saying, I can do whatever I want. I don't have to listen to this judge. That's not where she's at. That doesn't mean she did anything illegal or in any way violated any court's order. So, yeah, just wanted to sort of lay that out.
Okay. So I'm going to have Ms. Walker, if you could please unmute and state and spell your first and last names for the record, please.
It's Erica Walker, ERIKA WALKER.
And please, if you can please raise your right hand. And Ms. Filipski, if you can please also raise your right hand. Do you solemnly swear from the testimony about to give in this matter to be the truth, the whole truth, and nothing but the truth? Ms. Walker.
I do. Yes.
Ms. Filipski.
I do.
Okay. All right, counsel, I'm going to allow you to run your Ms. Walker in just one moment, but let me just clarify. Ms. Walker, what is your position and your job responsibilities with Abbott for Redwood Toxicology?
I'm a forensic toxicologist. What I do, review and interpret drug results for various agencies throughout the United States. Also testify to those results. I participate in testing from time to time. I also participate in litigation packets, which I provide, and also letters of interpretation and peer review and ongoing studies.
You've reviewed the testing results for Ms. Filipski. from March 26th to March 27th of this year?
Yes.
Okay. So my first question is, you heard Mr. DuBois' statement that Ms. Filipski was a heavy user of marijuana. And so I understand that it's dependent on individuals, but is there a way to determine how long something, a substance would stay in someone's system, specifically marijuana, a length of time?
Actually, for marijuana, just like fentanyl, it can stay in the fat cells. So it's hard to determine, especially if somebody's a chronic user. It can stay in fat cells for a long period of time. And also, too, it depends on the person's metabolism and other factors as well, like simultaneously taking other prescription drugs or other drugs. So it can vary.
Okay, and so it appears as though where it says the cutoff of
Yes.
50 nanograms per milliliter, what does that mean?
Anything above our cutoff is considered as positive or detected. Anything below the cutoff is considered as negative or non-detected.
So if a level was 47 nanograms per milliliter, that would be determined to be negative?
No, it's considered to be, it's above our cutoff. If you look at the right-hand side where it say confirmation, and it has 5 nanograms per milliliter by LCMS-MS, the instrumentation that it was tested from, it was above our cutoff, which is, our cutoff is at 5 nanograms per milliliter, so 47 was above that.
I'm sorry, I was looking at the THC.
Oh, no
Okay.
worries. Mhm.
And then the 205 nanograms on the ratio portion, what does that mean?
It just basically compares the drug to the creatinine in the urine, and creatinine just basically a byproduct of muscle metabolism, which is basically consistent over a 24-hour period. So it compares the drug within the creatinine, and usually creatinine just basically looks at the dilution of urine. So that's what that ratio is for.
Okay. And if an individual had stopped using marijuana 5.5 weeks before that, if they were a heavy user, and obviously based upon fat cells and metabolism, would there be a definitive determination as to when marijuana would have been used?
We wouldn't be able to tell that, but the thing is, if you had several reports, we can compare that to and look at you can look at the marijuana level, and it should be going down that ratio. You can compare that through time, and that lets us know if there's a renewed use or extended elimination. The thing is that we just got the previous report of the 26, and it was showing negative. And we can only compare those 2 reports together. And looking at that, because it's negative, when you look at the creatinine ratio was at 4.4, and that's considered as a dilute. Meaning that it's consistent with large ingestion of large volumes of water. Anything above 20 milligrams per deciliter is considered as normal, and this one is dilute.
Okay, so do you, in your opinion, based upon your responsibilities and your testimony and analyzation of these reports, as they're one day apart from each other, pretty much 24 hours, and the low numbers on the 27th, do you have any opinion as to whether or not you could determine if the 27th was new use over the 26th?
No, I would not to be honest with you and to be fair, if I had like another report, then I probably can compare. But because the day before it was ingestion of large volumes of water, just I still can't. I wouldn't be able to say that this person took new use of a drug.
And then what is the next test that you show, Ms. Walker?
These are only two tests that I have. It's the
Okay.
March 26th and March 27th.
Do you recall, Ms. Philipski, do you recall when you tested again after those two tests?
My notes reflect there's a test on April 15th.
I think there was one more meeting.
I can't hear you.
I think there was one or two more tests after that.
Okay. From that to April 15th, seems like a pretty big distance. I don't have any other testing, and that's where I was, but I don't see any other positives that are alleged. All right, so here's what I'm going to do. The court's going to find Ms. Filipski not guilty based upon the testimony of Ms. Walker and not being able to determine whether it's new use, and based upon on the levels, and then there aren't any other positives after the March 26th test, which would suggest that it was continuing to go down. And based upon the testimony of Ms. Walker that if somebody is a heavy user, it could still be stored in their fat cells. We're at about the 5.5 week mark from the date of the arraignment. The court's going to find Ms. Filipski not guilty. And I do appreciate your testimony, Ms. Walker. Thank you very much. I'm sorry, did you have any other questions, Mr. DeBlois?
None at all. Thank you very much.
Okay.
I appreciate it.
All
I
right,
know my client does.
thank you. All right, have a good day. All right, thank you. Continue with your bond,
Thank
with
you.
your probation terms and conditions. All right, let's go off the record for a moment. Okay, and then we are on the record in the matter of the City of Riverview versus John Fife.
There you are.
24469.
Good morning, Your Honor. Neil LeBlanc here on behalf of John Fife, who stands to my right. Mr. Fife, would you state your name for the record?
John Fife.
Thank you.
All right, thank you. Today's date scheduled for the arraignment pretrial today. I do apologize for your wait, sir. I know we were trying to call your piece a couple of times and Mr. Du Bois pulled in a lot of different directions today.
That's no problem, Your Honor.
Okay, and come for.
Yes, with respect to the arraignment, my client stands mute, charges, and we waive the formal reading.
All right, the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and then ask to the pretrial counsel.
Yes, I have had an opportunity to review this with the city attorney, and my client is prepared to offer a plea of guilty to the added count of operating while intoxicated. The original offenses of operating with a high BAC and open intox would be dismissed.
Okay, sir, please raise your right hand. Do you solemnly swear or affirm the testimony about to give this matter be the truth, the whole truth, and nothing but the truth?
I do.
All right, and you heard the plea that your attorney placed on the record, correct?
Correct.
And as to the amended charge of operating while visibly impaired by alcohol, how do you plead?
Guilty.
You've gone over your advice of rights with your attorney, correct?
Correct.
And you understand those rights.
Yes.
You also understand by entering into a plea that you'll be waiving some of those rights, specifically your trial and appellate rights.
Correct.
You also understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency. I'm sorry?
Correct.
Okay. And knowing all that, you want to continue with your plea?
Yes.
Any immigration issues?
No, Your Honor.
Anybody promise you anything, threaten you, or coerce you in any way for you to enter into a plea?
No, Your Honor.
And counsel, you can please run to your client.
Yes, I will, Your Honor. Mr. Fife, do you recall being in the city of Riverview on or about the 15th of April of this year?
Yes.
And at that time, were you operating a motor vehicle on the streets of Riverview?
Yes.
Prior to operating that motor vehicle, had you consumed any alcohol?
Yes.
What and how much alcohol had you consumed?
I believe it was a half a pint
Of?
vodka.
And do you believe that your consumption of that alcohol affected your ability to drive?
Yes.
In what way did you affect your ability to drive?
I was beaten.
I'm sorry, you were weeping? Is
Yes.
that what you said? Okay. thank you.
Yes, Your Honor.
And Your Honor, for purposes of the plea, we acknowledge the results of the toxicology.
Okay, and a .271.
Yes, Your Honor.
Okay, the court does find the plea is knowing, voluntary, and factually accurate. The court will accept your plea per the plea agreement. And you will get a sentencing date from probation that the court is going to determine your bond right now, sir. And to be quite frank, sir, I'm not sure how you weren't charged with the second offense, because don't you have a previous one from 2019?
I believe so. But I think that they just, I forget how it was worked out.
Well, my point is it's still 2 within 5 years. And so you really should have been charged with the second offense. But somehow you were not. So, counsel adds to bond.
As the bond, just a little prior statement regarding that. My client, I think maybe a candidate for Supreme Court, he understands that he has a problem. He is very upset and he's looking for help. And so we're hoping that door can be open for him. With respect to the bond, he advises me that he has kids. He's still supporting one minor child. He's been at the same employment for 20 years. Position of responsibility there. He's a supervisor, owns his own home in Taylor for over 20 years. Beyond this was apparent alcohol addiction. He seems to be pretty upright citizen. So he has appeared here voluntarily, and we ask for to continue the personal bond.
Okay. So if you were to test today, what's in your system?
Just probably alcohol.
When's the last time you used any alcohol, sir?
Last night,
And what did you drink?
vodka.
How much?
About a half.
Half a pint?
Yeah.
Yes, okay. And so you're not currently under the influence of anything, are you?
No, I'm hungover.
You like how that feels?
No.
No, I don't think you did. The court's going to order an alcohol tether. The court's going to also order you not to possess or consume any alcohol or drugs that are not prescribed. And the court will order that alcohol tether to be through EMS. You're to go today, sir, to do that. And you'll get a copy of your bond conditions. The court's going to order a $5,000 personal bond. All right, sir, have a seat open probation, and somebody will be with you shortly to give you a copy of your bond conditions, as well as your
Return date, right?
your PSI date and your sentencing date. Okay?
Okay.
Okay. Are you okay there? Are you okay there?
I'm just very nervous.
Okay.
I'm sorry.
Well, sir,
Yes.
you're not going to jail today. The court didn't order you to post a cash bond. Are you nervous because you can't consume alcohol and you're not sure how you're going to handle that?
No, I know I'm gonna handle it.
Okay,
This is a wake-up call for me, Your Honor.
it is. And given the fact that you have a prior conviction in 2019 and the level that you have this time, that's why the court's ordering the alcohol tether. And I'm just going to let you know that even without you telling me that you consumed alcohol last night, I was ordering that anyway. So I don't want you to think that your honesty is what got you the alcohol tether. Okay, I appreciate you being honest. And I think that says that
I
you
probably
need,
have some residual in me.
it says that you definitely need help, sir. Okay, have a seat over
I'm
probation.
seeing a therapist.
Okay, very good, very good. Continue with that.
Thank you.
Okay. All right, this is the matter of the City of Wyandotte versus Jason Mullins, 232279A.
Good morning, Your Honor.
Good morning.
No, it's afternoon. Good afternoon,
Good
Your Honor.
afternoon.
Field Blood here on behalf of Jason Mullins.
Jason Mullins.
Mason Mullins. Mr. Mullins, state your name for the record.
Jason Mullins.
Thank you.
Okay, well, so today's the date scheduled for sentencing on your client plea to property maintenance violation. And I gotta tell you, counsel, in this matter, I don't know what to do with your client. He continues to violate the ordinance, he continues to violate ordinances, canceled several inspections for the home, and 11 prior cases similar to this that he's been assessed fines and costs on to the tune of almost $4,000 and hasn't made any payments. any payments. I can tell you that he's not eligible for 771.1 status. That I can tell you based upon his prior criminal history. Sorry, I didn't mean to take the wind out of your sails, counsel, or steal your thunder. And you can advocate for your client, but I'm just letting you know where the court's coming from with this matter.
I understand, Your Honor. I reviewed the record. I reviewed this with Mr. Mullins. The report takes no issue with the factual basis, the factual outline in the record. He has presented to me today a couple of permit approvals. So it is still an ongoing issue. It does not have the final COO. It asks the court to adopt the recommendation and place him on probation and consider shortening that probation when he comes back with the certificate of occupancy. This is his home. It's not a rental. It's not.
Can I say something?
Okay.
All right, I got these two approvals in my back pocket here. I'm working hard toward this. My wife has tenure and I'm not pitiful. I'm a single dad. I take care of my 70-year-old mom. I work full time. And in the meantime, when I do these repairs at my house, I don't have the money to spend all these thousands of dollars for this. And I wasn't aware of all them tickets. I knew there were a few, didn't know until $4,000. The thing is at this point, I called the city and they told me, get your permit inspections done. Those are done, they're approved. For the final certificate, I talked to Jesus at the city. He said, let them in, let them check the stuff out. They're coming in Wednesday. I'm honestly trying to work with what I've got. I am.
Well, okay, and so I can appreciate that, but even if you were to set aside or make payments of $10, right? That's something. You're not just ignoring the court and your obligation. So here's my question, sir. You said that you're a single dad, but did you also mention your wife? So, she passed away 10 years ago. Okay, yes. I'm sorry, because you started to talk about your wife and then you went into single dad. So
I'm just a guy. I got a 12-year-old son at home and I've been raising him for 10 years. And then my mother, she's 70, which ain't that old, but she's lost two of her children in the same amount of time my brother and my sister passed. And it's like she's kind of an emotional basket case, so I got her with me and I work full time and then I try to get these things in order whenever I have open time, but I'm there. I'm near the finish line now. I really am. And like I said, I had no idea that them tickets amounted that much, or I surely would have made payments.
Okay, well, here's what the court's going to do. The court does find that there's reasonable grounds to park MCL 769.5 to make sure that all this is getting done. Yeah. And I know it's an unusual type of case to have on probation, but I think that direct oversight will kind of help focus you in a little bit with that. So you are eligible for early discharge. You're not to violate any criminal law or need of government. You're not to leave the state without the consent of the court. You report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You're notified probation officer means of any change in address or employment status. I'm going to order 60 days jail. It's suspended. It just means, sir, that if you're not getting this done, you can serve time in jail, right? I know it may be a silly case for that, but it's still a criminal type case, and so I want to make sure it's all getting done. So the court's going to also order for defendant to continue with improvements and inspections. Defendant to set up payment plan on outstanding costs. Okay?
Yes, ma'am. And so when they come out Wednesday, because I got everything on my original, that's all done. What I've done here is I've started other projects, and it's small stuff like base trim and paint. So there's a possibility that they'll pass this and give me my CFO, and if that happens, can I bring that in and maybe be done or no?
You can bring it in, but here's what I'm going to do. Here's what I'm going to order. So we're going to order a $200 fine, $100 screening assessment fee, $1,200 supervision oversight fee. That's $50 a month at 24 months. If that you're eligible for early discharge, you may not have to pay all of that. $300 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50. I'm going to total that up for you. It's going to be a lot of money, but I'm also going to say that that's all going to be suspended if you pay all of your previous fines and costs in full. There's some incentives to make sure those are all paid in full.
And they will be.
Because I will not have you discharged from probation unless those are all paid in full.
All right, so if
Okay.
I pay them in full, I'll be able to discharge. Even
Well, if everything's done, let me see, well, it's $19.25, so if you want those waived, make sure your other $3,900 is getting paid in full.
Okay, so I'll pay that in full, and then I get a CLO, so if I do that in 3 months, everything will be good, or no?
It could be, I can't predict what the future is gonna be, sir, but, it could be, okay? Sorry for your ears. Okay, anything else?
No, that's it.
Nothing further.
Okay. All right, have a seat over in probation. Somebody will be with you shortly, okay, sir?
Thanks again, all right?
All right, thank you. Good luck to you. Have a good day.
All right, you too.
Thank you. We got that one more. All right, let's go on the record in the matter of the city of Wyandotte for Sam Seife. 24628 A, B, and C, or A and B. And we'll get to clarifying how I mispronounced your name in just a moment, sir. Okay, and counsel your appearance, please.
Yes, good afternoon, Your Honor. Neil LeBlanc here on behalf of Sam Seife, who appears via Zoom from the jail.
Dave, that was not a problem. I was just confused.
Oh, okay.
Okay, and sir, your name please for the record.
I'm Seife. Speak up.
Sam Seife. Okay. Okay, and counsel as to the arraignment.
Respect the arraignment, my client waives the formal reading and stands mute to the charges.
All right, the court will waive the formal reading, enter plea of not guilty for purpose of the arraignment, and we'll schedule this matter for pre-trial on May 29th. All right, and as to bond counsel.
As to bond, my client indicates his knowledge, there are no warrants or holds on him on any other court. He is indicates that he has employment lined up with Sam's Club. Other relevant factors that he's in the application process to join the U.S. military and the branch of the Air Force. We ask the court to take those things into consideration, set a nominal fine. He also, again, on I guess on a personal level, indicates that he has no ability to get a hold of any cash. His mother is someone he hasn't been able to get a hold of. Apparently, she is hospitalized at this point, and it's very difficult for you to think that the cash bond. We would ask the court for personal bond.
So, Mr. Seife, you don't have a valid driver's license, is that correct?
I didn't know it was not valid, Your Honor, to be honest. I mean, I was, before I get back to my mom, I was living to friends, house to house, so I didn't have an address to check on my mail.
So you don't live in Ypsilanti?
And now I'm back at my mom's to help her, but before that, I was just living at friends' house to house, so I didn't know what
Okay,
was
so
the situation.
the Secretary of State and courts cannot track people down where they move. So if you received a citation, you didn't pay it, what happens is that you don't get the driving privileges. If you were to test today, sir, what's in your system?
I'm sorry, what was that?
If you were to test today, what's in your system?
Not intoxicated.
I'm sorry?
Are you asking what's in my system?
Yes.
No, nothing. I was not intoxicated at all. I actually told the officers if they wanted to arrest me right there, but they didn't.
Okay. So, have you ever failed to appear in court for any reason, sir, other than your traffic matters?
No. Not
Are you currently out
not
on bond in any other jurisdiction? Are you currently out on bond in any other jurisdiction?
no.
Are you on probation or parole anywhere, sir?
No.
And so which Sam's Club are you set to begin employment, sir?
So the one on Carpenter Road, Ypsilanti, I used to work there. I just had a lot of anxiety and depression going on, so the doctor just prescribed me so much medicine, and I wasn't sleeping a lot, so I just had to absent leave until I feel better and go back.
Okay. All right, given the fact that you failed to appear previously for court matters, which is why your license is suspended, the court's going to, and the fact that you don't live here in the local area, the court's going to order a $5,000, 10% bond in this matter. In the event you post bond, sir, you're not to possess or consume any alcohol or drugs unless prescribed. And then we'll see you back on May 29th. And also no driving, sir,
Yes.
unless you're cleared from the Secretary of State.
Yes.
All right, thank you. All right, have a good day. All right, off the record.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. We need an interpreter.
I need an interpreter when I cannot express myself sometimes.
Joke. Oh my God, sir, put that cigarette out. I don't give a crap that you are outside and this. What is wrong with everybody today? You know what, Miss Green? We're gonna start bringing people in person. People are gonna learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
I have no patience for that. Trust me, out of the day, I'm sitting up here, I'm the one that needs the drink.